Welcome to the Five Stone Buildings webinar programme. We have just opened the live link, so we're just waiting for a few minutes to allow everybody to join before we start. Whilst we are waiting for people to join, I shall just remind you of the house rules. So just to remind you that this webinar is being recorded. If you have any questions throughout this webinar, please put your questions into the Q&A box at the bottom of your screen, and our speaker will try to come to your questions at the end if we have time. If you do not wish to be identified when asking your question, then please tick the anonymous box so that our speaker will not identify you in their response. And I'll just remind you that we now have a separate section on the Five Stone Buildings website for webinars, where you'll be able to find a copy of this recording and any slides used and any previous webinars that have taken place. I will now hand over to Alex.
Thanks, Jo. Hello, everyone. I'm Alex Drapkin, and I'm going to talk about mutual wills. It's talk that comes out of the administration of an estate that I've been involved in which the deceased made a mutual will and then regretted it after the death of his wife and made a new will. And we have been instructed by the personal representative, and we've had to deal with really a myriad of issues that come out of that. None of them good or desirable, really, and this talk touches on very few of them. But although there's a lot written and quite a lot of discussion about how mutual wills work technically and the basis for them and whether they're a good thing or not, that there's very little out there about what happens when they go wrong and then you have to administer the estate. And it may be something some of you have come across, but some of the issues struck me as tolerably interesting, or what passes for tolerably interesting in traditional chancery anyway. They're obviously less common than they were, and I'm of the view that that's basically a good thing, because there are a few doctrines in the private client world that give rise to more difficulty, or whose exact technical workings are more opaque. I think the attraction of them is that they speak to a very human desire to control what happens after we die and to be sure that that is what's going to happen. And therefore, there are quite a lot of mutual wills out there, and people do still create them. The difficulties, in my view, tend to arise when that emotion collides with another very human desire or another very human characteristic, which is a propensity to change one's mind. And this talk really comes out of what happens then. It's probably worth just briefly looking at exactly what a mutual will is and what it isn't. I'm sure everyone's familiar with mirror wills, in which usually a couple, but two people make wills in identical but mirrored terms. So often husband and wife will make wills that leave their estate to each other and in remainder to the children, or in substitution to the children. And mutual wills are similar, but effectively become binding after the death of the first person to die. So, Jo, if we could have the next slide, or the first slide. I decided it was difficult and perhaps unwise to try and define them better than Mr. Justice Morritt did. And there's a quote there where he explains that where two individuals have agreed as to the disposal of their property and have executed mutual wills in pursuance of that agreement, on the death of the first to die, the first testator, the property of the survivor, who he calls the second testator, the subject matter of the agreement, being that property, is held on an implied trust for the beneficiary named in the wills. The survivor may thereafter alter his will, because a will is inherently revocable, but if he does so, his personal representatives will take the property subject to the trust. And there, Mr. Justice Morris is talking about a scenario in which the agreement between the first to die and the second to die was specifically over the whole property of the survivor, both that inherited from the first to die and that which he or she had already. But as we'll see, people make different agreements in that respect, and that can give rise to particular problems. And those problems can arise even before anyone seeks to resolve from the agreement or change their mind. Many of the initial problems start when people try, in my view, to get too clever, perhaps, about the property that they are actually seeking to seeking to govern the disposition of after their death. And that property is usually defined in the mutual wills agreement, which is almost always found in the two wills themselves. And then there's a second issue that can arise where, for whatever reason, the agreement does clearly apply to some property, but not all the property that the second to die has, and the agreement has become binding, and those funds have become mixed up, and the poor personal representative has the job of disentangling them. So looking at the first issue, where people have tried to be quite clever or specific about the property that's going to be bound by the agreement, usually mutual wills agreements are expressly defined to bind either all the property that the survivor holds on their death, so both what they inherited from the first to die and anything they've got in the meantime and anything they had originally, just what they have to leave in their estate on death, or just the property that they inherited from the first person to die. And you can see, depending on the situation between the couple, that might be an attractive option for them, it might not. But sometimes you see more complex directions. And on the next slide, which if we could have, please, Joe, perfect, I have lifted one from a will. For example, this one purports to make the agreement binding only in respect of the residuary clauses in the two wills. And this provides a really great difficulty in ascertaining the extent of the agreement, which may well be necessary once the first to die has died, the second to die has inherited their property and wants to know what they can and cannot do with it. What is bound by this agreement? Well, if we look at clause 3.2.2, says the obligations to which this agreement gives rise, and then jump over 3.1.2 and come down to 3.2.2, are, quote, not to prevent changes in the non-beneficial provisions of our will. Well, fine, that's just about the appointment of executors effectively and the administration clauses, nor changes in the non-residuary dispositions of our will. So effectively, anything left that isn't part of the residue. Now, in this will, there was both a specific gift and a residuary gift. But the difficulty in interpreting what the mutual wills agreement means is that the doctrine of mutual wills binds property. It doesn't bind specific gifts. It sets out the obligations that the second to die has in respect to the property that they hold on their death. And this description doesn't make it clear what property is bound. Is it, for example, all the property that they have on their death, save for that which would be required to meet the non-residuary gifts in the will that they originally made? So if there was a specific legacy in this will of £100,000 and then it all becomes binding, and then can they only change their will up to £100,000 effectively? Or is it any property that they have which they then choose to leave by specific gift rather than allowing to fall into the residue? I think it's probably the case that it's got to be the first option, because otherwise you could have the survivor of a mutual wills agreement made in this form, changing their will to leave everything they had by specific gifts rather than allowing it to fall into residue, and completely defeating the point of the agreement, which would be rather unsatisfactory. But it's not at all clear, and this can be one of the issues that either everyone has to agree or one might end up in court. This agreement actually goes a step further, because at 3.1.2, it says not only have they made the provisions in the next clause, but also it only applies to the property inherited from the first to die. And that makes the question you have to ask yourself about, well, what property does this bind? If it's only residuary and it's only the inherited property, what's the best way to interpret that together? I think the question is, does it bind such property, such inherited property, only above the sum of the original non-residuary gifts? So is it everything over £100,000 of inherited property on the basis that you would have paid the specific legacy out in the original will out of the inherited property? Or is it only the inherited property to the extent that, looking at how much of their own money the second to die had on death, you would have needed the inherited property to pay the £100,000? Or do you say to yourself, well, they had £100,000 of their own on death, so they could make the specific legacy that they were always allowed to change, and therefore all of the inherited property is bound by the mutual wills agreement? There simply isn't any answer to that question, and I think probably if there's a dispute about it, you need a personal representative to apply for court for declarations to the construction of the will. And I think it's if one is going to make a mutual will, it is better to make a simple one than a more complicated one. I can see that these clauses were put in to try and make things simple and straightforward and specific, and they've had exactly the opposite effect. The second problem in relation to what property is bound that I mentioned briefly is perhaps a more common one, because by and large these problems aren't, these clauses aren't so specific. A couple may have made a mutual wills agreement, for example, where the agreement binds property that they inherit from the first to die. So far so good, relatively straightforward. And for example, a husband and wife might make such wills where they leave the property that they have to the other one, and again in substitution to their children. So the husband dies first, as actuarially I suppose he will, and the widow inherits his assets, and that might comprise his half of the matrimonial home and his half of their savings, which we'll assume weren't joint property. And the widow is then the absolute owner of her original share in the matrimonial home and her original share of the savings, but she takes her husband's former share of both of that, subject to the mutual wills agreement. Which, for example, if the beneficiaries maybe were his children from the first marriage, would make perfect sense. But if she then remarries and wants to make a new will in favour of her new husband, conceptually it's pretty clear that she can leave him her original assets, but not those inherited from her husband. So she can leave him her share of the house and her share of the savings. And while that might be quite straightforward with the house, and it might even be relatively straightforward with the replacement property that she's purchased by selling the house, she's going to have to be unbelievably disciplined to keep the cash separate, so that 20, 30 years later, if she has a long time without her first husband, she's able to say, well, yes, this is bound and this isn't. And that problem is particularly acute when you think that it's not only the capital sum that's mutual wills property, but it's any income or gains on that capital sum. So almost inevitably, she's going to end up blending the inherited property with her own property. And this is really difficult because whether or not she makes a will that seeks to respect the agreement, or she breaks the agreement, disinherits the mutual wills beneficiaries, and they bring some claim to vindicate their rights. The poor personal representative who ends up with all this property in their hands has got to decide how this property is going to be separated out. And as I find almost every section of this talk ends, there's no definitive answer to this question. You have to have recourse to a careful analysis of the exact position of the widow, and in my view, the law on the mixing of trust funds. Whether or not the widow is actually a trustee in the way that equity lawyers like to think of trustees is an open question, and it's one that actually the cases are very careful not to answer. But it's definitely the case that she's subject to some sort of fiduciary obligation in the nature of a trust, because equity will enforce this agreement and the property is clearly bound in some manner that's akin to a trust. But it's an unusual trusteeship because it's generally accepted that she can use the property for her own purposes. So the classic example is that she could pay care fees out of it. No one, the mutual wills beneficiaries can't complain if she does that. But what she can't do is leave it to someone else or give it away during her lifetime in order to defeat the agreement. So in my view, the fact that she's allowed to use the property for her own purposes suggests to me that she's probably permitted to mix it, albeit that unmixing it is going to be necessary and is going to be very difficult. And if mixing the property is not a breach of trust, then which it usually would be, because if you're the trustee of a private trust or a classic will fund or something, if you mix that property up with other property, then that's a breach of trust and you're going to be liable for any loss, including the costs of unmixing it. If you're the professional personal representative, for example, and you mix two estates together, it's going to be pretty obvious that that's not something you can do, and that's going to be a breach of trust. But if it's not a breach of trust to mix it, it's just something that needs to be unmixed, then one has to think about how you treat the unmixing, because in the very unlikely event that she'd mixed the property up, the inherited property and her own property, but she hadn't spent any of it, fine. All you'd have to do would be to unmix it, and it would be difficult and expensive, but possible. Sorry, my phone's ringing, I need to stop that. Difficult and expensive, but possible. But in this case, she will almost certainly have spent some of it. So the question arises, is the how are the losses, if you like, caused by the fact that she spent some of the money to be borne by the two funds, the property that she has to leave to the mutual wills beneficiaries and the property that she's entitled to leave to her own beneficiaries? And I'd suggest the answer is that you don't treat her as a wrongdoer, and therefore you don't say she must have spent her own money first, which is what you usually say about trustees. So you probably apply the rules on innocent contributors to a mixed fund, which is a horrifically technical and contradictory area of law with very old cases and a lot of disagreement. But broadly, the starting point is a case called Clayton's case, and that says, well, in a way, you apply a first in, first out rule. So sums drawn out of the fund are attributable to the earliest deposits into the fund. So if she started with a bank account with her own money in, say £100,000, she then put in £100,000 of the inherited money, which you can see might happen after it was remitted to her by the personal representative of her late husband. If she then spends £100,000, well, she's taken to have paid out the earliest in time first, and therefore effectively the mutual wills beneficiaries do well because their money is taken still to be there, but the people who would inherit her unbound estate lose out because she's taken to have dissipated the money she could have left them first. But that analysis is quite disproportionate to undertake because obviously the numbers will never be as simple as that, and the time period may be very long. And in addition, it's a bit unfair because that example has the attraction that she's also taken to spend her own money first, which, although not the right approach, at least makes it feel more sensible. But if that wasn't the way in which it happened, if perhaps she deposited money into the inherited bank account rather than the other way around, there's no real reason why the order in which the funds were mixed should govern how they've been spent, and therefore what should be deemed to remain in the pot, whose money. So I think probably a court will look to jettison the rule in Clayton's case in favour of what's called the pari passu approach, which basically just means that the contributors to a mixed fund, in this case the mutual wills beneficiaries and the free estate, the people who the widow could leave the money to, will share ratably to how much of their fund went into it, regardless of what's left. So if the widow's own assets at the beginning were £500,000 and the inherited assets from the husband were £500,000, then they clearly shared 50-50, these two funds, the mutual wills fund and the what I call the free estate, that which isn't bound by the mutual wills agreement. And so regardless of whatever's left at the end, we'll split it up 50-50. And that's quite attractive. The only difficulty is where there've been contributions from one source or another afterwards, but it is possible to work out what the percentage is. It's an expensive exercise for an accountant to do. It's one which we had to do in the administration I've been involved with, and it can be done, but it's certainly something the personal representative needs to think about. Of course, in an ideal world, everyone would just agree these figures. You'd have sensible adults. But where you've got trustees or beneficiaries who are underage or people in that capacity, that maybe it won't be possible to get agreement, and therefore you may have to do the work and then go to court. And even where there might be agreement, your beneficiaries might say, well, let's have the accountant's report and see what we're entitled to. So although I suggest that's a potential approach to how you might separate out mutual and non-mutual wills assets where you had to, there is again no authority on the topic, and personal representatives should be very careful and consider these things very carefully. It might be necessary to apply to court for directions if you can't find agreement. And this stuff can have a real effect on the values that the beneficiaries get. If you've got a situation in which the widow knows that she's got to leave the inherited property to one set of people, but she wants to leave her own assets to someone else, how you do this tracing exercise, and depending on what's gone up and down in value, may be really important in terms of who gets what, regardless of whether or not it's coming as a deliberate change of mind or breach of an agreement or something. Where you do have a deliberate change of mind or breach of the agreement, really difficult questions can arise in the administration. And to be honest, they can also arise even in more straightforward cases, like the example we've just looked at. But lots of these questions arise, or they're caused by the fact that the personal representative of the survivor of the agreement finds themselves administering two separate funds. They hold the unbound fund, the property that the deceased was free to leave to whoever they wanted, as personal representative of the second to die, and they should administer that on the terms of the deceased's last will. However, they hold the other effectively as constructive trustee of the mutual wills agreement to administer it according to that agreement. This is in a situation in which the deceased made a mutual wills agreement and then breached it deliberately by making a last will effectively. The trusts of the mutual will, of course, be those contained in the mutual wills agreement, which will be in the will that was a mutual will. So it's like you have two parts of the estate and two different wills to administer it according to the terms of. Just one of the questions that one gets faced with in that situation is how you apportion the administration expenses. It's suggested, or I'd suggest, that that's a matter of just construing the two wills that set out the relevant trusts and seeing what they say about their own administration expenses. But you've also got to consider their relationship to each other. On the basis that both the wills contain standard form residuary clauses that direct the administration expenses, which will of course usually contain inheritance tax, will be payable out of residue, whatever is meant by that document, then it would seem to me that the most straightforward construction would be for the two funds, the mutual wills assets and the non-mutual wills assets, to pay their share of the expenses out of the residue of that fund. But it's not remotely clear what the right way to calculate that share would be. For example, the expenses could be divided proportionately by the value of the funds. So, you've got mutual wills assets worth £500,000, free estate worth 250,000. You've got £100,000 of administration expenses, and you allow the mutual wills assets to pay twice what the free estate pays. But what if the free estate has actually contained assets that were much, much more expensive to administer than the mutual wills assets? Is that fair? Is someone going to complain? Is a beneficiary going to be angry? Similarly, you've got the same problem with the inheritance tax. If all the assets across both funds are chargeable, and if all the beneficiaries are chargeable, so you've got no APR or BPR property, and you've got no spouse or charity gifts, then it might be fair and straightforward for all the inheritance tax just to be borne again in proportion to the value of the funds. Sort of smear it across both funds and give both of them the benefit of the deceased nil rate band if they have one. But what if the beneficiaries of one fund are charities, so wouldn't pay any IHT anyway under normal circumstances, or rather they wouldn't pay as much IHT as they would pay IHT that was dictated to be borne out of residue within the instrument under which they take, but there's no real reason for them to end up paying the other IHT borne by the residue in a separate fund. They may complain that may not be fair. Again, the same applies to the administration expenses other than the tax, and there's no authority on any of those questions. And unless agreement can be found, a personal representative is really going to need to go to court and also involve the revenue quite closely. There is also incidentally no authority on the question of whether you can get a sort of discount on the taxable value of the estate on the basis that the deceased was not in fact free to leave it as they hoped. Sometimes people argue that, and they also argue it in relation to proprietary estoppel cases where an equity has been created that arguably lowers the value of the estate of which the deceased was able to dispose. And that may be something personal representatives might like to investigate in these cases, and the beneficiaries may want them to. If they do have to go to court, I should mention, it also occurs to me, they may also want the court to expressly grant the personal representative authority to charge as trustee of the mutual wills trust. But they'll usually have authority as personal representative, but a lot of what they'll be doing may be as trustee of the mutual wills trust, and if they're a professional, they will almost certainly want that cleared up. They may, they want to clear it up. So to sort of conclude, there are lots of difficulties with mutual wills. There are particular difficulties where people deliberately change their mind, but these difficulties can even arise where everyone had the best intention. It's just that the agreement makes the property extremely difficult to divide up. I mean, other issues that we haven't looked at today include should the personal representative be recovering gifts of the mutual wills assets that were made specifically to defeat the mutual wills compact. I mentioned briefly the entire inheritance tax treatment of the mutual wills trust, and can you avoid a charge on death on the basis that the deceased was not in fact free to dispose of it? How should clauses in later wills that are made in breach of the agreement that contain IHT concepts like the nil rate band or the residential nil rate band or the charitable legacy, how should they be interpreted in a situation in which the taxation of the whole estate isn't really clear? And in my view, given their complexity and uncertainty, I would not advise recommending mutual wills to clients in general. Lawyers whose clients really, really want a mutual will might wish to consider quite carefully whether they're willing to act as the personal representative under them. Might want to advise that someone else be the personal representative. That may also be something that professional personal representatives want to consider on death if it turns out that a mutual wills agreement has given rise to difficulties in the administration or has been deliberately breached. It is not necessarily something that every professional will necessarily want to be engaged in, particularly where the assets could conceivably be insufficient to make the fees proportionate, because it will be a lot of work. But that's not always the case. I mean, it can be good and interesting work. I think probably that's all I will say today about mutual wills and their administration. I was speaking to a solicitor a few weeks ago who said that she had enjoyed Chambers webinars, but they should be 5 minutes long instead of an hour long. This one has obviously not been 5 minutes long, but neither has it been an hour long. I also, I'm afraid, am not going to offer to answer your questions this afternoon because I have an advocates meeting in half an hour, and then I have to be in court. Otherwise, I would be delighted to do so if anyone really wanted more information about mutual wills. But I hope what I've said has been useful and as interesting as could be expected. And thank you very much for listening.